All right. Why don't we get started? This is Patrick Youngs here. We really appreciate everyone who has joined. And just very quick as we get started, wanted to let you know that you're going to be getting a lot of information today, and just want to let you know who it's coming from. TalentWave has been delivering, IC compliance solutions for the last 23 years. So it is core to what we do. This is something that we dive deep into every single day. Over that time, we've evaluated more than 60,000 independent contractors, and we've supported our clients through 12 state and federal audits. And with the compliance team and Rob, who leads that team, joining us today, he and his team, they've never had a 1099 evaluation overturned, and our clients have never received even $1 in fines. And so it's with that type of rigor, that you're going to be getting all the information that you're getting today. And so moving forward, you'll notice three key themes in today's discussions. The first one is compliance really is king. It continues to lead this industry, the IC compliance industry, primarily because there's so many legislative changes. And now we're seeing different interpretations in case law. And so that's the other theme that you will see. And then finally, just the fact that you really have to take an intelligent approach, a different approach than you did even 2 years ago, to make sure that you're safeguarding your organization and staying compliant. So some of the things that are happening out there in the market, what's driving all this change? Certainly, this has been a unique year. I think the statistic that really stands out here is when you see that 33% of Americans no longer work for the same company that they worked for in February. That's a staggering number. When we see that much movement in the market, what we tend to see are pretty significant spikes in the number of independent contractors that are working out there. And you'll also notice that according to the Bureau of Labor Statistics, they estimate that 43% of U.S. workers in 2020 will contribute to the economy somehow. So that's a really large portion of the American workforce. And we're seeing that show up when you take a look at organizations that work directly with independent contractors. Upwork, up 12% year over year, even in a COVID year. Fiverr, up 82%. And those are platforms that deal primarily with independent contractors. And so what you see is, it tends to be, as you see big shifts in employment, you also see, significant spikes or increases in the number of people that are working as independent contractors. And then the end result of that is you begin to see even more legislative changes. And so that's really kind of brought us to this discussion today of, AB2257, Prop 22, and even, new language that's going to be coming out from the Department of Labor later this year. Rob, with that, I want to hand off to you, and maybe we can begin to dive into some of the legislative changes that we've seen.
Yeah, and Patrick, so what you're saying from that former slide is independent contracting is not going away.
Seems to be that way.
Seems to be that way. Okay,
seems to be heading in the opposite direction for sure.
Mm-hmm. Yeah. And speaking of that direction, as we talk about legislative changes, 2020, what a year overall, a tumultuous year overall, and a tumultuous year in the space of independent contractor compliance. You could see we're going to talk about a lot of activity and then some specific things that we've said we're going to discuss, like Prop 22, the Department of Labor. But you can see from some of these headlines that are sort of strewn about on these topic slides, there's just a lot of activity and action. It's not all, as restrictive as, say, California's laws are. There are laws that go the other way that are more, engagement friendly for ICs. There are some of those as well, but most of them do put more clamps around and restrictions around how you can use an independent contractor. And so I would like to say, just before we get started here, we're thinking about this overall, and you want to think, what are some trends we're seeing, and that you're going to hear highlighted throughout here. There's a few things that I'm seeing out there this year, and that's new class of work, new class of worker. So something other than an independent contractor, as we know an independent contractor to be, something other than a W-2 employee, as we know that to be. There's new classes being formed. They're here. And where will they go from here? Also, something that you'll see touched upon here and to be aware of are what I like to call misclassification microclimates. So these are, where the state may have one set of regulations, but there could be a large city, think of New York City, San Francisco, Minneapolis, that also has additional scrutiny on using independent contractors. And because they're that large of a city and you're doing business there, you may have to be aware of things on the citywide level, not just state and federal. And the third thing to think about is the debate and legislate sort of cycle continues. A lot of debate out there openly in news, on Capitol Hill, and then a lot of legislation of different kinds, not just the laws that we're going to talk about here, but things like establishment of task forces and all that. So these are three of the trends we could talk about as we move into this this game board here. So, as we go through this, we're gonna talk about some of the things that have happened just since the beginning of this year. This year is coming to a close here rapidly. This is not a sort of exhaustive list, but it might feel exhausting. There's a lot on here. We'll start with what happened at the beginning of the year. In January, New York said that they want to be tougher. New York State, the governor said they want to be tougher on independent contractor misclassification than California. As an update, I do believe that current events have probably moved that statement to the back burner. So yes, while I think that New York will want to legislate anew around worker misclassification, I don't know that they're going to want to go to the limits that California has gone to, because California has served as a sort of an example of maybe what you don't want to do, and we're going to get into that as well. Next on the game board here is New Jersey. New Jersey is another state that was considering a California type of ABC test. That was almost in effect as of last year, and it did not pass. They thought they'd get back to it this year. In actuality, that could be like New York. Does New Jersey want to go through the sort of open fighting that California is going through? Perhaps not, but they did pass their own suite of worker misclassification laws back in January. That's 6 laws that make it tougher to qualify your independent contractor in that state. And we add to that, this goes to the third class. We add to that the Federal CARES Act in March. This had to come through, this had to pass, but this provided employee type of benefits to non-employees, to ICs. So it kind of muddied the water in a necessary way, of course, but it muddied the water around, well, what is an IC? As a company, I can't give unemployment benefits to an independent contractor. Oh, but I can under the Federal CARES Act. A lot of confusion there. Okay, then what happens when this winds down? What are we left with? Is there something that I can do that I couldn't do before with my ICs? This is, again, the third class that we're talking about. Rounding the first curve here. In March, so California and its AB5, AB2257 law has been assailed on all sides. Certainly it's supported here in the state of California where I sit, but also has many, many detractors. So this was the first step in March, people turning in signatures to vitiate this law in the state. But as we move to other parts of the country, Pennsylvania, in April, they passed they had a very big court case there that clarified the standards for independent contractors for purposes of unemployment and compensation law. So Pennsylvania is another very active state when it comes to misclassification. In fact, most recently, the governor there established a task force to kind of find and root out misclassification and punish the companies that are doing it. And so keep in mind, this is what I mean by task forces. Sometimes it's easier for a state to establish a task force. In other words, to create a commission or a body to go and look for independent contracting misclassification, to fund that body. It's easier to get that done than it is to pass a whole new law. And that happened just recently there in Pennsylvania as well, as an update. If we're moving along a little further, in May, California went ahead and weaponized AB5 against Uber and Lyft in that now sort of famous or infamous lawsuit. And moving ahead into July, Virginia, for its part, also signed a series of misclassification laws as well. So we see that happening now. And Virginia was typically considered a sort of pro-business state, maybe a little more lenient on things like independent contractor and classification. These sort of tighten the clamps around there in what's sort of a reversal of how Virginia historically looks at independent contracting. As we're making that second turn on the game board, the Department of Labor aimed to fast track its own misclassification law, and we're going to get to that, what that means, what it doesn't mean, what it does, and what it doesn't do. And then further into July, Massachusetts. This is an example of what I see out there of states enforcing existing law, not just creating new laws like California did, but enforcing their own existing law. Massachusetts is a state that has the ABC test on the books for the last 17, 18 years. In July of 2020, they went ahead and used that ABC test to sue Uber and Lyft. That is still ongoing. An example of a misclassification microclimate, that would be Minneapolis. So in Minnesota, there was an ordinance approved that employers, well, they say employers, but businesses engaging with independent contractors need to have written agreements with their freelancers. New York City has this already for the last couple of years, the Freelance Isn't Free Act in New York City. So again, this is something where you have to pay attention to what a city is doing. It might have additional requirements even beyond what the state does overall. And in California, that brings us to the amendments we're going to discuss. AB2257. These were signed under an urgency clause, meaning that it was so urgent to have these amendments to AB5 enacted that they were considered valid and to go forward the second that Governor Newsom signed them. And so that's where we're at there. Of course, we're going to talk about that. And to finish off this board, Missouri created their own task force again. Another task force to look at worker misclassification. What I'll say is that we're living during a time where tax revenues, the tax coffers are short, obviously, and misclassification is not the hardest way to recoup some of those tax shortcomings as well. And a task force is a good way to do it. And then lastly, Prop 22, we're going to talk about that. That did pass. And we'll get more into that. The thing about this game board here, the way it differs from sort of a game you might have at home, is there's no rules with this game board. So it's very hard to track what should I be doing as a company, or even who am I as a freelancer if I cross state lines and sometimes into other cities. And so that's a part of the tumult that I described earlier. Well, if we move to the next slide, we're going to talk about AB5, AB2257, but I'd be remiss if we didn't move forward without once again sort of flogging you about the head with what the ABC test is. By now, if you've been following some of these webinars, we've talked about it a lot, and somehow I still get Patrick to come on these with me and listen to it anew. But again, just to reiterate, what is the ABC test that AB5 is predicated upon? Three things. So AB5 mandates that an engaging business classify all their workers as employees unless that business can prove the following three things. So the business has to prove them all. The worker is free to perform services without the control or direction of the company. The worker is performing work tasks that are outside the usual course of the company's business. And the worker is customarily engaged in an independently established trade, occupation, or business of the same name or same nature as that involving the work they're performing currently for you. So this is the preeminent, I'm not sure, prevailing test in California. As we mentioned, this is also the test in Massachusetts as well. A difference being is in Massachusetts, this is the entirety of it. This is it. What you're looking at is Massachusetts' law on worker misclassification. In California, there's 14 pages to muddle through, thousands of words to try to figure out. It is a bit difficult to track if you're trying to apply it. What's to know about this? Well, we talked a little bit. This could be the test in other states. It was almost certainly going to be the test in other states prior to what has transpired in California, which might be backing other states off a little bit from wanting to use it, but still could be the test in other states. And not only that, could be the federal test under a Biden administration. But the Biden administration has supported the PRO Act, Protect the Right to Organize Act, which would codify at a federal level. What you're seeing here on this, not the picture with the string tied around it, but the actual test itself. It would codify this as the law at the federal level, which we have not had. So whether that would come to pass or not, we don't know, but it has been talked about. So as we like to say in compliance, get comfortable being uncomfortable.
Yeah. Okay. So Rob, quick test here. Based on AB5 and now AB2257, would Mary Poppins be considered an employee under California's misclassification test, or would she be an IC? And while we're at it, what about the Mandalorian? And let's talk about Mr. Miyagi as well.
Well, yeah, and Patrick, we'll thank our good friends at the law firm Greenberg, Torig, and Fisher Phillips first bringing these kind of issues to light as this test would apply to the Mandalorian and Mary Poppins. Mr. Miyagi is TalentWave's own sort of contribution to this conversation. But really, last year we talked about the Mandalorian. Would the Mandalorian pass the ABC test? I was on with a partner of mine, Neil Baumre, who, if you want to know anything about the Mandalorian from head to toe, he will tell you he's very engrossed in it. We found out that the Mandalorian really wasn't going to pass the ABC test. Now we've come to a new year, and Mary Poppins, I believe, Patrick, the magical nanny, would what she's doing pass the ABC test, in your opinion? What do you think, Patrick? I'll give you the first.
So, this is almost too easy, Rob. I'm already going to say it. It really comes down to prong B, doesn't it?
That, and that's where I think you're actually wrong, Patrick, because,
okay.
There's a first time for everything, Patrick, no worries. If you think about the whole point of doing this in a way as well, just to kind of have a little bit of a detour from what we're doing, is also to see that sometimes laws have unintended consequences, and they drag in populations, that maybe really didn't need to be covered by the overarching law. Maybe. In the case of someone like Mary Poppins, Patrick, I think we can agree she's free from control. She's in there. She's helping the family. Yeah. She's bringing them closer together. And I don't think that they can instruct her how to do that. As far as are they outside the normal course of business, that would be the family's normal course of business. And so since they don't run a nanny supply service, or otherwise, I think that she's actually okay.
She might be safe there. Yeah, prong C might get her. What do you think?
But I want to talk about, that's right, prong C. Does she have an established business? And I got to admit, I really don't know much more about Mary Poppins, but I don't know if she has other clients. And if she hasn't been doing this for very long and doesn't have some other invoices to show us, prong B might actually sink her in California. And the family's going to have to provide her with, W-2s and some benefits and paid leave and things like that. So I think that's where we're going to come out. Now, Mr. Miyagi, who's to say? He's sort of a tutor, right? Or a spirit animal for young Daniel. but honestly, he could be sunk on the same thing, prong C. Although I will say that under AB 2257, there is a tutor carve-out. So if he is considered a tutor, he could be carved out from having to qualify with this test, but only if he's working through a referral company. And Patrick, it's been a long time since I've seen this one. I don't think Mr. Miyagi's working through a referral.
I hear you, but therein lies the challenge, and you brought it up. AB 2257, all the exceptions. You feel like you understand it, and then you have to look to the exceptions, and then there's exceptions to the exceptions, and then even further exceptions from there. I think that's where this becomes a challenge.
In application, absolutely.
Yeah. And I think that brings us to our first audience poll.
Perfect.
That's right, folks. We got a poll here, and we want to know, just a reminder from what we went over at the beginning of the housekeeping, just use the polling widget to the right-hand side of your screen. You can plug your answer in there. So what we want to know today is, how long has it been since your organization established a new enterprise IC compliance program? Is it A, don't have a program at all? B, 0 to 1 year, 1 to 2 years, 2 to 3 years, 3 years or more? We want to know that. So I'm going to give everybody a little bit of extra time, but I will be interested to see what the results are here as I think a lot of this in the news maybe has prompted some of you to get more organized about this. So maybe you've got younger programs out there where you're just starting off in the 0 to 1 year range, but possibly you're a little bit more mature and you're 2 or 3 or more years into this kind of situation. So let's take a look at the results here and see what we've got so far. Oh my goodness. So a lot of people here do not have a program at all. What do you make of that, gentlemen?
Yeah, well, go ahead, Rob.
Sorry, Patrick. I see opportunity, for the program to be started now. And I mean, it's kind of sounds silly, but because it sounds trite, but what better time than now? I mean, as you've seen from some of these earlier slides, it's tumultuous, as I've said. So if you're going to start, if you don't have one, now is definitely the time to start. While things are as complicated as they've been in a very long time.
Yeah, I agree, and I think one of the things that doesn't surprise me a lot is that 0 to 1 year, just because, Rob, we talk about this a lot on these webinars. When you look at the last 2 years, there's been so much more change in that 2 year period than there was in the 20 years before that, right?
Yeah.
And so, and even like with what the game board that you did for the year 2020, there's been so much change even this year, and more to come with the Department of Labor. That I think in the past, what would happen is organizations would say, well, we've got some means of dealing with this at some level, right? But I think now that the situation is things are so complex, they're moving so fast that organizations now are having to respond and build something out. So
yeah, absolutely.
Excellent. Well, let's take ourselves back to the slide deck here, and we'll keep rolling.
So now we're going to talk about AB2257. You could say polarization. You have a name, and it is AB2257. Patrick, I was going to say something maybe like Webster's 8th definition of the word reviled is AB5, but I thought maybe that was cool. And it's not wholly true. Obviously, these laws have a whole lot of support, and there's universal support, of course, for protecting exploited workers. But did AB5 do that? Well, whatever AB5 did, it didn't do it well enough, because AB2257 has come down within the same year that AB5 was enacted. I mean, I think that speaks for itself. But let's find out then if AB2257 did sort of create a better law or improve what AB5 was, or whether it didn't. And let's find out together. So what is AB2257? In September, Governor Newsom signed it into law, and again, had that urgency clause, so it's in effect right now. It supports businesses in various industries who utilize ICs, and it helps to clarify some of the ambiguities, and there are many of them that were called out associated with AB5. The new bill effectively replaces AB5. So AB2257 is AB5. They are one and the same, or AB5 is gone. AB2257 is what you should be reading in total. And that codifies and clarified the Dynamex ruling to use ABC test. So ABC test didn't change. It's still there. That's still the test to satisfy in California. And I should say, too, that if you satisfy that test per the law, you still have to satisfy the normal test, I should say, the previous test in California, that's Borrello. So, you've still got to satisfy that test as well. And now what does it do further? It provides many exceptions or exemptions to the application of the ABC test. Those exceptions each provide that in the event the ABC test can't be applied, as I said, that determination is governed by the Borrello standard, which was California's law for about 30 years. What does it mean for workers? Freelance writers, photographers, translators, and musicians will be among those getting exemptions or changes to existing exemptions from AB5 to continue working as independent contractors rather than employees. So that's the jacket blurb, but let's open the book. And so here's where I guess I begin to start sort of an erudite discourse, but hopefully not overly pedantic. But I do have a couple of lessons if you walk away with something here and you're in California working with this. read the fine print. Just please read the fine print. I study worker misclassification laws. I've studied this one. I read also openly what's being written by all sorts of sources about this law. And I can say that for the most part, they're very sound. But you got to watch out because because this law is 14 pages long and connecting the dots is extremely challenging. There is a lot of unintended misinformation about this about this AB2257 being written out there. So just read the fine print of the law itself. Find someone will do that for you. But please don't take anything you read out there in the blogosphere or whatever articles as fact. That could put you in hot water. All right. But let's talk about what this is really about, and everyone's happy that there's more exceptions. So really there were about 40 exceptions under AB5. We had open debate, eggs being thrown, so to speak, at the authors of AB5 saying, what about us? We're like them. Why aren't we included? So they went back to the drawing board, so to speak, added another 25 or so exceptions. I'll give you an example. One of the most widely reported on problems with AB5 or cited as why AB5 just made no sense was the 35 submission cap that freelance photographers and writers had under AB5. So under AB5, a freelance writer can work with one business entity 35 times. Great, they're an IC. 36, now you're not an IC anymore. And it seemed arbitrary, capricious, all that good legal language, and it made no sense. So AB2257 said, we hear you, we have heard your cries, and there is no more cap. But read the fine print. What they've done is replace that cap with further requirements. And this is a trend within AB2257. What the law giveth, the law then taketh away, or reverse, or whatever you'd like to say. So instead of that 35 max cap, now you have further requirements that you didn't actually have under AB5, such as now you've got to have a written contract specifying pay rate. You can't work primarily at the hiring entity's business locations. The hiring business entity can't put restrictions on you for working for more than one entity. And here's the one that's really going to cause, issues of head scratching, as you see here, is the work that freelancers doing can't be replacing an employee who performed the same amount and type of work for the hiring entity. So I would pause there and just wait for questions. I know we can't do that maybe at the end, but that is truly kind of confusing, open to interpretation, and sure to provoke litigation. All right. So again, please read the fine print here. Know where your carve-out is. We get calls, we consult. I'm on the phone quite often talking about, hey, I think we've got an exception here now under the new law. Is that the case? Maybe. We'll get emails that say, I am this, I am now, I don't have to comply with ABC. Maybe. So keep in mind that this law has different levels to get an exception. You have to prove it harder if you're a certain job than if you're another job. Okay, I don't know how fair that is, but it is what it is. So I'll give you some examples. If you're a physician, a dentist, a podiatrist, a psychologist, you're carved out completely from having to satisfy ABC tests. You go right to Borello for the most part, right? You have to be licensed. There's a couple things, but those things kind of come along with the job. So those, you're carved out completely. But if you fall into, graphic designer, a grant writer, a fine artist, well, now to get around ABC, you've got to satisfy 6 additional factors, 6+ factors, really. And if you're a tutor, a caddy, a pool cleaner, a dog groomer, now there's 11+ requirements that you need to meet each time you want to be an independent contractor or have this person be paid as an independent contractor to get around the ABC test, get to Borello, and that kind of work has to be through a referral agency. So as you can see, merely having the name as part of this law, it may or may not actually help. So who wins? We look at it overall. If you're looking at the big groups that were addressed under 2257, you had things like recording artists, musicians, vocalists, individual performance artists. So again, read the fine print. So when we talk about recording artists, we're talking about, it's limited to the recording industry. So we certainly have a lot of clients that utilize creatives. We're very adept at working with these kind of populations. And we know in reading this law that actually this law doesn't apply if your music, your recording ability is going into film. It's really not, that's not part of this. It's recording industry only. So for whatever reason, there's this sort of sub factor to look at. Also, if you're talking about individual performance artists, I mean, think of sort of the sense of this. What is the difference between an individual performance artist, or let's say, what is the additional risk of misclassification around an individual performance artist as opposed to a group? Or another way to put it is, what are we trying to remedy for an individual performance artist who may be being misclassified or exploited that we would not be trying to remedy if you were part of a group? So these are some high-minded questions, but these are the things that sort of we grapple with in working with this, because this is how it has to be applied until there's further guidance or litigation opinions that we can go to. And I think one thing that I'll mention too about this is just be careful further about a lot has been reported around language in the law that says includes but not limited to language. So sometimes this is reported as, that's great. That means that we can, a business can argue that, this one particular job function that's not specifically named within the law is still like enough to jobs that are specifically named that they can be included too. That's that includes but not limited language. And that's true. It does loosen up and allow for non-mentioned jobs to be included, but it only that language only applies to referral agencies. Okay, so as we move forward, we've got the carve-out exemptions. Patrick, let's go through each and every one of these 50 or so. I believe everyone's got time for that.
I'm sure, yeah.
But these are the AB5 carve-out exemptions, and they're kind of to walk away with so you could see what's there. And again, as I say, I like to bucket these things. You have the bucket one, which is your go straight past ABC test in most cases, right? You have your bucket two, 6+ factors and some more factors. And then you have your bucket three, the business of business exception. So different buckets for different jobs. Now, as we move to what some of the additional carve-outs are, they're here for you to look at. And, when you look at when I look at these, what I think of is, why these and why not those is certainly. And I also think, as laws are remedial, what remedy is being provided to, say, perhaps a professional forester? Were they being taken, a competition judge? Because again, the law is seeking to right a wrong. Were competition judges something that we had to? Most of these were already sort of ICs by nature, so not sure that they had to be named. But it does lead to certain further debates, just like under AB5, of why this and not that. I think if you can provide the rhyme or reason for the exemptions that are named, let me know. That'll be fun. And then we have to ask ourselves, if there are hundreds, if not thousands, of additional jobs that are left out that maybe should be in, what happens next?
Yeah. And Rob, I think, just to point out too, some of this language is very specific, and yet some of it leaves much to question. And I'll give you a really good example. The, third or fourth down, the digital content aggregators. If they stuck just with digital content, then that's an easy category, right? But when you put the word aggregators in there, it really,
it's very specific.
Yeah.
And it is defined. These things are defined in the law. So, before the last thing I'll say is that, what did it really loosen? Well, it brought in some new job functions. It had some requirements. It did loosen certain requirements. So an example is under the B2B exception, whereas before under AB5, Patrick, the independent contractor had to actually be contracting with other businesses to provide the same services. Now it's just a can. So it's not a requirement. It's just a can. Same thing under B2B. Before under AB5, the business could not be providing any tools or equipment to the independent contractor. Now there's this sort of reasonableness language that's attached to that. You can't provide tools unless they're proprietary, kind of something that's maybe needed that you wouldn't be expected to have. And then finally, if you're thinking about the professional services exemption, where those graphic designers, fine grant writers, and fine artists reside, there's used to be a requirement. The requirement was you have to have a home office, you have to have an office that's separate from the client. Now it is still required to have that separate office, but it doesn't prevent the contractor from wishing to, if they wish to work on site, if they wish to work with the client, they are allowed to do that. So there's some of those things that are loosened a little bit, which, I mean, forward thinkers like myself, I think we were already kind of reading some reasonableness into this law anyway, and maybe already doing that, but some of that stuff is now hard coded in the law. And that's going to bring us to Prop 22. Definitely going to talk a lot about this. In California, it is really been debated. The Uber and Lyft scenario has been litigated for years here. This brings potentially the end to those debates, but with the law, there's always more ways to kind of litigate this if so chosen. That being said, California Prop 22. Let's talk about that. So this was a proposition put to the people of California, asking them to decide whether app-based delivery drivers could be ICs or should be W-2s. The state of California said they should be W-2s because the Uber and Lyft case that the Attorney General brought against those companies, it was already decided that they were W-2s, and what was happening prior to Prop 22 going in was that Uber and Lyft were going to have to reclassify their drivers to W-2s, maybe leave the state, who knows? That was going to happen. Now, not so sure. So that's what the state of California said. They're employees, but what did the people of California say? They said they're ICs by a majority vote, and a pretty good one, which we'll see on the next slide when we get there. This did pass. So what is Prop 22? Well, without going into every last detail, the purpose here for Prop 22 is to protect the basic legal right of Californians to choose to work as independent contractors with rideshare and delivery network companies. It also protects the individual's right of every app-based rideshare and delivery driver to have flexibility to set their own hours, where and how they work. And then it requires these companies to provide the rideshare and delivery network drivers with new protections and benefits under its wording. And lastly, it commits to improving public safety by requiring criminal background checks, driver safety training, and other safety provisions to help ensure that the drivers do not pose a threat to customers or the public. So that's its purpose. How does it get that done? Well, and remember, this applies to just what I said, just these drivers. Well, it gets it done by stating that an app-based driver is an independent contractor, not an employee, if all the following apply. The company doesn't prescribe dates, times, minimum number of hours that the drivers need to work. The company doesn't require the driver to accept any specific rideshare services or requests. Okay. The company doesn't restrict the driver from performing the same kind of services to other network companies. And the network company does not restrict the driver from working in any other lawful occupation or business. So that's how it gets it done. So what do the drivers then get along with this? So it's independent contractor status, freedom to work how they want to. The companies themselves have committed to providing things like a healthcare subsidy consistent with the average contributions required under ACA. New minimum earnings guaranteed to 120% of the minimum wage. All right. Compensation for vehicle expenses. Maybe that was the most litigated, was who pays these expenses for my vehicle, as well as occupational accident insurance, and protection against discrimination and sexual harassment. So, so basically, you know, what we get here, if we put it all together, I know I should add that this one's not going away. It would take a 7/8, you know, not the best math guy, but 7/8 vote to amend this in any way. So that seems pretty impossible. So Prop 22 seems like it is going to be here in California. So, you know, we can move to the next slide there. That's the nuts and bolts of it. It passed. 58% said yes, 42% said no. This is California. I live in California. This is a landslide if you're looking at a California proposition as, you know, potentially polarizing as what was at stake here. There was, even down to the day of the vote, there was speculation that maybe it wouldn't pass. Well, it passed by a lot. So obviously this is a big win. And I don't know, seesaws, I haven't been on one. I don't know if the higher, Patrick, means you won, or the lower means, well, I guess, if you're on
perspective, isn't it?
It really is. I've been on one of those in at least a few weeks, but so it was a 58-42 vote. So obviously it's a big win for the companies that paid for it. This was about $200 million went into this by those companies like Uber, Lyft, DoorDash, to put this on the ballot and to get this passed. Labor groups are, you know, clearly unhappy with this as well. Think it was the wrong call. And then, of course, is tech legislation around the U.S. going to become, let's say, a thing? Well, as we talk about those ramifications on the next slide, you know, we're gonna bring that up. Certainly, listen, if you are one of these extremely well-funded companies and you just got this passed in California, why wouldn't you take this show on the road? And in fact, Uber CEO has already indicated as such that they're planning to create these propositions in other states. So Illinois, New Jersey, where Uber has been assessed a tax bill of, I don't know, in the hundreds of millions, 400 million or something like that. They could, for not taxes, but for unemployment contributions. That bill is outstanding, just sitting there on the table. So maybe the next thing is the same thing happens there. Proposition goes out to New Jersey. How about Massachusetts? We said they're being sued currently by the Attorney General there. So Massachusetts is a proposition coming to the people of that Commonwealth, right? And will it go the way that California? Well, if you're proponents here, you've got to be optimistic. Again, passed in California. So what's to say it wouldn't pass in any state? But beyond that, there are other takeaways here. Is it making other states more cautious? Okay, a little. We don't want to go down the California road. We want to back away from a harder stance on misclassification and maybe something more like whatever we have in place now. So the easiest thing to other states that were considering an ABC test to do is to look at the example of what's gone down in California. California passed a law. It was assailed from all sides, had to pass amendments, still being hit hard from all sides and criticized. And then a vote was put to the people who said that the real main targets of the law could remain as independent contractors. And meanwhile, you know, I should say that inside of California, there are legislators, one in particular, who is still going to put bills out there to repeal AB5, AB2257 altogether, planning on doing that, or put AB5 repealment to a vote next year. So who knows? Perhaps we have a vote again to the people of California to say, do we even want AB5 anymore? Well, if you're another state, you really don't want to have that potential egg on your face and that open kind of debate. So what you might do in those states is back away from the ABC test, pick something a little more centrist, or maybe just stick with what you got and try to enforce it a little bit harder. So is it the death knell for AB5? Well, no, it isn't. I mean, we know that AB2257, AB5, they address every independent contractor. So there's a lot of meat left to chew on if you're thinking of who that law applies to. But does it effectively gut it or weaken it? Well, I mean, in reality, we know that these Ubers and Lyfts were really some of the main targets that led to the creation of this law. Now that those targets are presumptively outside of the law, does this law make even less sense than it ever did? You know, does it kind of work in reverse and actually, you know, hurt people who it was seeking to protect? So these are things that are going to be certainly be debated. And one thing is clear: Uber and Lyft and DoorDash, they've created a third class of worker. That's just what it is. You know, they're providing things that used to be absolutely a no for a company to do without risking misclassification. They're providing benefits, safety training, anti-discrimination protection, health, death insurance. And they're also sort of skirting around having to try to prove, not even skirting, clearly stating that there is nothing to prove anymore under usual standards for determining if someone's an independent contractor or not, such as Uber and Lyft spent small fortunes in trying to say that drivers are their own independent businesses. Maybe they lease their own car. Maybe they have other drivers underneath them. It's an independent business because traditionally that's what you have to prove under independent contractor laws. No more. I've read this proposition, and you know, it clearly states that most of the people who do this for additional income. So again, you used to have to prove it was a business, and you don't have to do that anymore. So many things to come as we move forward here. Just quickly, we'll touch upon the Department of Labor. The Department of Labor has a new law, or new rule, excuse me. You can move to the next slide here. I'll go through it. And it's supposed to make it easier to qualify independent contractors under the FLSA, okay? And it's a multi-factor test. I call it a 2+3 test. So basically there's two core components in determining if someone's an IC, and that's the nature and degree of the individual's control over the work. Do they have a lot of control over their own work? And the individual's opportunity for profit and loss. If that doesn't solve it, you drop down to these three additional components: the amount of skill required for the work, the degree of permanence of the working relationship between the individual and the business, and whether the work is an integrated unit of production. Look, we're going to move fast on this one here because we don't really know if it's going to get off the ground. It's a Trump administration initiative. The idea was to get this in before the end of the year. Things are moving that way, but you know, this is one of those rules that when the new administration takes over, they could look to really soften it or retract it or find other ways to lessen its the effect of it. As you see, there are lots of people who are both for and against it. What's important to know, even if this does go through, it doesn't relieve companies of their obligations under the IRS, the state, or for misclassification microclimates, you know, perhaps the city. Those obligations still exist. So if you're still in California, you still have to deal with AB2257, no matter what this does for you. What this really does is potentially unify the courts at the federal level, such that when an FLSA case comes there, it's a given how that should be analyzed and determined.
Rob, if I can, before we get into this next audience poll, I want to make sure it's not missed, because when you talked about Prop 22, you brought it up. But when you look at what the CARES Act did, and then you also bring up Prop 22, the impact that we see beyond just Prop 22 in California, but everywhere, is just a continuing nudge, or maybe even more than a nudge, in the direction of creating a new classification of worker, right? So we've worked forever with two classifications, a W-2 or a 1099. We just see more evidence of something you've been writing about for a few years, which is the potential possibility that a third classification of worker becomes a real thing. So, you know, and you might want to comment on that for a few seconds, but just, I think that's one of the things we don't want to miss with Prop 22.
Yeah, the new questions will become, you know, in the short term will become, sure, can we pass propositions like Prop 22 in other states? The longer question, and I think the more widespread ramification question is, what does a new third class look like? And when can my business start doing this and making an experience better for my independent contractors without being fearful that I'm turning them into employees? Lots of stuff.
Yeah. All right, I think that brings us to Yeah, thank you, Alan.
So just the same routine as last time, everybody. We're going to take a look at the widget to the right-hand side of your screen and check one of the options there that applies best to you. Of course, this time the question is, how prepared is your organization to be compliant given all the changes that have occurred in 2020? So I think this is definitely, you know, just from between the legislative changes that we've been discussing and then, you know, everything else in between, this has got to be on a lot of people's minds right now. So I am going to be curious to see what they say in response to this question. Okay, just one more second there. Yep. And okay. Again, very much a clear winner here, even more of a majority than last time. What do you guys think of these results?
Just briefly, you know, somewhat prepared. And I'm thinking of the last question where companies didn't have, the majority of companies didn't have a sort of a program for this. So I'm trying to sort of make those make sense in my mind.
Yeah, it's and I think, you know, to the point we were making a little bit earlier, to the things that haven't changed, maybe there's preparation, but there's so much that has changed. It's hard to be in that very prepared bucket up there. It's just extremely difficult right now to look at your organization and feel like you're very prepared from everything that we just went through.
Yeah, you know, and in my mind, I expanded this to just an overall life question, and I still couldn't put myself into very prepared. So just in general, I'm somewhat prepared. That's pretty much going to show up on my tombstone if I get that.
These days, somewhat prepared
down in time.
These days, I don't think anyone can say very prepared. I think somewhat prepared is as confident as we can all be.
That's right.
That's right. Okay, so we'll take it back to the slides here, and I'll let you guys wrap up here.
Yeah, that's great. Thank you for that. And then we'll get into questions really quick here. I think, you know, as Rob and I look at this and as we work with clients, you know, there's still just that opportunity to say, all right, we are going to have a clean slate in 2021. You know, how do we might have some challenges right now, or there might be things to work through right now in terms of our compliance and risk levels. But how can we make 2021 as clean and risk-free as possible? And I think that's what we're hearing is on most organizations' minds. And then, you know, I won't go through all of these. I'll bring out just a few. You know, in terms of like, gosh, how do we execute on something to make sure that we are safe? I think the main things here are, number one, just, you know, do an analysis internally, or work with a partner to do an analysis internally, gain full visibility to your IC workforce, and then categorize that workforce into high and low risk. You know, where is my risk and how can I, you know, do something about it? That's the first thing. I think the second thing is just, you know, make sure you've got a program where you come back and continuously reevaluate independent contractors through time. I think that's one of the biggest challenges we see is, you know, in the past, it might have been okay to evaluate an independent contractor up front and then they're good for the engagement. But every engagement tends to morph closer to an employee-employer relationship, as opposed to the opposite. You know, they just always tend to drift in that direction. So having a program where you actually come back and reevaluate, you know, independent contractors on a regular basis, I think is a really good thing. And I think the final thing we'll leave with you is, you know, if you've got a trusted partner, lean on them, you know, and if you don't, there's no harm in just at least talking to potential trusted partners that they could share with you maybe some ways that you can mitigate or free yourself up from the risk that you've got today. So those are the things I think that probably put you in the best position to be free and clear of the risk that's out there today. And so, Alan, we might have some questions that have come in. Just let us know.
Absolutely. We do have a couple of questions already in here, but I want to let everybody know or remind everybody that the Q&A box is just below the webcast viewing screen. So just take a gander there. And if you have a question that you want to ask our presenters today, please let it rip. So first question I want to get to here is from Ruth. And Ruth wants to know, could one of you define outside the course of normal business?
I'm going to leave that up to you, Rob. I'm going to put myself on
How much
mute.
time you got? Well, I have talked extensively with internally and multiple outside counsels to really see, look, how would a judge or an auditor try to use that? I can give you these helpful things. Believe it or not, if you're under judicial scrutiny, they're going to send their law clerk to look at your website, the About Us page, what's prominent on your own website, how you describe yourself, and they're going to use that as kind of first and foremost. So that's that might be helpful, and sort of how you describe yourself would be thought of as your ordinary course of business as one. Of course, there's more, but that's a good start.
Great. And another question here comes from Tom, and Tom is wanting to know, you mentioned some cities have worker classification rules that extend beyond federal or state rules. Do you have any examples of which cities have done that?
Yeah, right now you want to look to New York City and Minneapolis as both requiring written agreements with your freelancers, your independent contractors, with varying requirements in there. I mean, the good news is, if you're using an agreement of any kind, you're probably going to be covered. You just got to stick to things like payment terms being in there, and then adhering to meeting those terms. Because if you don't, the penalties are really sort of civil in nature. But so if for instance, you don't pay somebody on time, you could be rung up for fines around the lateness.
Gotcha. And another question here comes from Carol, and Carol wants to know, how do you think the changes we're seeing and all of that will impact IT professionals, computer programmers, developers, etc.?
I mean, it's an interesting question, because oftentimes IT professionals are some of the populations that are really, they draw a lot of attention. They get a lot of deference, let's say. So IT professionals may not want to go through some kind of a vetting type of scenario or program. And a lot of times there's exceptions made. I think it's tough, depending, again, going back to that usual course of business. The good thing about IT professionals, generally speaking, they're not who these laws are looking at primarily. They're highly compensated. They can provide their own benefits, so they don't need your social safety nets. They're well tenured. So where you have those things, you're probably in pretty good shape. Where you have people who don't meet those, or maybe are just getting off the ground, it's a little more tenuous.
I see. All right, well, that is, I'm looking at the clock here, that is all the time we've got for today's webcast. Just a reminder to our HCI members that today's webcast has been approved for HRCI SHRM credit and HCI recertification credit. Your credits for attending this webcast will soon show up in your My HCI dashboard. Just click on that area in the top right-hand corner of your screen, click Learning, then click Downloads Transcript. You'll get everything you need there. Just wait about 24 hours and all the credits for credit codes for this webcast should be populated in your transcript. And while you're there, don't forget to check out hci.org for even more free content, as well as information on our certifications and events. And of course, as I mentioned at the top of the hour, do stay tuned for more information about dates and how to purchase tickets to our big slate of virtual only events next year. You're not going to want to miss these things. They're really a lot of fun and really worth your time if you're looking for some way to stay entertained while you're developing yourself. And finally, I'd like to say one more thank you to our presenters today, to the good people at TalentWave. Thank you guys for really making this thing a possibility, giving us really timely information on some stuff that literally just changed last week, basically. So I can't say better than that in terms of up to the minute information. So we thank TalentWave and our presenters in particular for making this all possible. And I'd also like to thank you, our webcast viewer. Thanks for spending an hour or slightly more with us. We will see you next time.